Well, good morning. Good morning. Here we are with HR office hours.
Very good.
Here we go. Here we go. So I'm Sandy Zannino, and I'm here with my friend Brad deBeaubien. And don't forget to like and share.
Please.
Uh, yes, we have some great information for you today. What we decided to do was revisit because the FTC has closed the comment period for a little something that they did not that long ago. So Brad, could you bring us up to date? What's happened? Are there any updates with non-competes and the FTC?
Sure. So you may recall we did an episode about the FTC's proposed nationwide ban on non-competes, and we kind of use that as a platform to talk about non-competes generally. They're at this point in time regulated by state law, but this is a proposed nationwide ban. There's some maybe limitations on what that could ultimately look like, but part of the process of the FTC attempting to roll that law out that would ban non-competes across the nation is understanding, well, how do they go about doing that? What is the process? As Sandy mentioned, there was a public comment. So they proposed the law. Then there's a public comment period where they solicit, input from the public at large. And I think this has to be the single most comments they've received on any proposed law, right? This has just gotten a ton of attention. The original period was supposed to end in, I think, March 20th, and they ended up extending it for another month to April 19th or 20th. So it's just closed. We're here in early May. That public comment period has just closed, and they got tens of thousands of comments, I think across the spectrum, right? The chambers of commerce and the business community came out in force saying, hey, non-competes are essential to, operation of our businesses. We got to, shame on you, FTC. And then, of course, on the other end of the spectrum, you have consumer advocates who've said this is a real impediment to people moving within their industries. So what the FTC, is now doing, I think, is digesting those comments and will ultimately probably propose a final rule, which they'll publish then and say, okay, this is the law we're proposing to enact, or we are enacting. There's, I think, 180-day period though between the publication of that final rule and then when it becomes effective. Mm-hmm. And what I think we can expect to see is some legal challenges once everybody knows what the proposed final rule is that's on the books. Then you'll see the legal challenges to everything from it's too broad, to the FTC doesn't have the authority to even do this. I mean, there's a whole spectrum of legal challenges I think we can expect to see. So for employers, nothing has really changed insofar as there's nothing to do today, but did want to sort of update everybody that comment period is closed. There was an overwhelming amount of comments from all sides of the issue, and now we're just waiting to see what the FTC is going to do with that by way of, are they going to propose a final rule and put it on the books, and then will those legal challenges ensue? And if the FTC goes forward with the rule, I think we'll certainly see legal challenges. And so when this will ultimately become law is anybody's guess at this point.
And I guess what that law will look like in the end, because it's a 6-month period, that 180.
Yeah, that's my recollection, is that it's 180 days from when they publish the final rule to when it would potentially take effect. And like you said, right, as written, it's a pretty comprehensive ban on all non-competes. There's no exceptions for highly compensated individuals or for C-suite executives or for this or that. There's a couple of carve-outs for sellers of businesses, and I think another one in the franchise or franchisee context. Those are the only limitations on the potential ban. But other than that, this would just wipe out use of non-competes kind of across the board. And so it's a major change that's in contemplation.
So I'm really curious about the piece in the franchisee context.
Yeah, and I don't have a lot of specifics on that other than knowing that I think that lobby's probably done a pretty aggressive job of saying, hey, there's a lot of money that changes hands, and that is sort of central to our business model would be that folks not, leave the franchisee web and then become competitors. So we need to be able to restrict that on some level, at least for a reasonable period of time.
So Brad, for our viewers in Florida, right, because that's where we are, as it stands right now, because it's regulated by the state, what kind of would be enforceable and a not enforceable non-compete?
So Florida has actually a statute that speaks to non-competes. Some other states have statutes, and yet others have just sort of a developed law through the courts and judicial decisions. But in Florida, we have a specific statute that says to be enforceable, a non-compete has to be in writing and signed by the person that you want to enforce it against, right? So it can't be in your handbook. It can't be something that they agreed to verbally on the way in. It's got to be a signed a contract executed by the employee, and it has to support a legitimate business interest of the employer, and that's a whole other topic as to what that entails. And it needs to be reasonable, and I think this gets to what you were asking about, Sandy. Reasonable as to time, geography, and the scope of the business, right? And so in Florida, and Florida's a pretty employer-friendly state, meaning courts will generally enforce non-competes, whereas in some states they're really forbidden, and California is kind of the other end of the spectrum in that regard. They don't generally permit non-competes in most contexts, but here in Florida we do. So you asked about time. I'd say as a general rule, anything from a year to 2 years is sort of what we see as standard and what we see courts upholding. The statute speaks to presumptively reasonable and presumptively unreasonable. Anything that's shorter than 6 months is presumptively reasonable. Anything longer than 2 years in most contexts is presumptively unreasonable. And so you see most employers kind of playing in that 6 month to 2 year space with the timing. And again, I think 1 or 2 years duration for a post-employment non-compete is pretty standard.
And is it a good idea for an employer to differentiate what level of employee is they asked to sign a non-compete? C-suite versus frontline worker, or an admin, worker?
Opinions vary on this. I certainly think that it does. And I think there are, again, a non-compete, just because somebody signs a piece of paper, our sort of golden rule that anybody can contract for anything doesn't work in this context, right? Because we have a statute that says, well, in order for this to be enforceable, there has to be that legitimate business interest that supports it, which means the employer has to be able to point to something that's really worthy of protection and that justifies keeping the employee out of the job market for whatever period of time, whether that's protecting confidential information or trade secrets or some extensive training that the employer has invested in with respect to that employee. And so, the folks in the C-suite obviously have access to a lot of certain confidential information. They understand the business and customer list. I think there's probably a much more compelling case for keeping those people from going across the street to the competitor where they would take a storehouse of knowledge with them and potentially use that to the advantage of the new employer, as opposed to, say, the person who answers the phone or the person who works on the factory floor. I can conceive of situations where that person might also have some knowledge that would be worthy of those protections, but generally speaking, no. And I think we've got, and this is kind of really what's motivating the FTC here, is that non-competes are just sort of run rife anymore, and everybody's using them, and it creates, and I'll, as a frontline lawyer dealing with this, it creates a mess of problems, right? I mean, we have folks that come to us with legitimate needs for enforcement, and then we have a lot of folks that's like, well, I had these people sign this and now I got to look strong because they signed a piece of paper, but it's like, well, this person just manufactures some product for you. They don't really have any specific knowledge, and what are we doing here? So I read as I was telling you, I always like to grab business headlines and sort of see what's kind of in HR space, what's going on in the news. And yesterday's CNBC headline said something like, speaking to this issue, the existence of non-competes cost the U.S. economy $300 billion a year, right? I think the implication meaning that, employees' inability to move to a new job and make more money, the sort of total loss is $300 billion. And I think that's a big number, and it's very compelling. The flip side of that coin, if you're a business owner, and I'm principally represent businesses in these issues, not individuals, is if my people are leaving all the time and feel like they can go willy-nilly, that costs me money too, right? I got to recruit somebody else, I got to train somebody else. Maybe that person doesn't work out, and I'm as a hiring partner in my own law firm, I can tell you there's a real cost to that too. So there's a flip side of that coin, and it doesn't lend itself to an easy answer. I'm not sure that an outright ban, as currently conceived by the FTC, is the right answer. And I hope that if we see them go forward with this, that they sort of slice and dice it a little bit more finely, but we'll see.
I hope so too. I think that sometimes, I mean, this is just my opinion, right? One opinion, but I think that sometimes it's that there's no middle ground. There's the, okay, we're going to have everybody sign a non-compete, and then somebody can't go make an hourly worker, can't go make $2 an hour more
Right.
across the way. But I do think that that non-competes are essential to some businesses at the, at higher levels.
Yep.
There, so maybe the end up rule, the rule that comes at the end of this 160-day period will be something that is in the middle. Wouldn't that be nice?
Yeah, we'll see. We'll see what they, like I said, they're noodling on the comments right now, and whatever they roll out as the proposal here, anytime now, or who knows when. Maybe some departure from what was originally proposed. I think that would be smart, but I don't have a seat at the table, so we'll see what happens.
We'll see what happens. So, Brad, it's been great spending time with you as always, and we'll see you all next time on HR Office Hours. Please like and share, and join us next week.
See you then.